Chapter 17, The Charge. We are covering from section 211 to 224. Part 1 of chapter 17 was how to learn all the sections through a trick word. Part 2 was covering section 211, and in part 3 today we're gonna cover section 212 to 213. We have already covered section 211 in our previous video lectures, the contents that are 7 parts. Let's revise it. The 7 parts of 211 says, state every offense. How you gonna state it? Name the offense. If there is no name, define the offense. State the law and section under which such offense comes. Check that all the facts has been fulfilled. It should be written, and if the person has been previously convicted by the court, mention that in the charge. It is going to enhance the punishment. Section 211 covered. Now let's cover section 212. Now 212 has 2 parts. 1. TPP and 2. The gross sum or the property. Let's check what they are. Let's cover section 212 in detail. The particulars as to time, place and person. The title itself informs us everything which is going to come under section 212. Subsection 1 of 212 says the charge shall contain such particulars as to the time and place of the alleged offense and the person, if any, against whom. Why we have written if any? Because sometimes we do not know whether it is one person or even a thing. It further says or the thing, if any, in respect of which it was committed. This subsection 1 of 212 is very important because sometimes an opponent or the accused says you have not mentioned the exact dates. The subsection 1 says that even the item may not be specific or exact dates. Sometimes we do not know exactly on which date the offense was committed. The last line says, as we read, as are reasonably sufficient to give the accused notice of the matter with which he is charged. Now we have to give time to him to prepare his defense. Why we need to give time to him? Well, because we want that he should know what offense he is being charged. He can prepare his defense if he is innocent, not if he is guilty. This is where we sometimes lack as an advocate, that the time should be given only if we think the accused is not guilty. Now let's cover an important case related to subsection 1 of 212. Banamali Tripathi versus Emperor AIR 1943 PAT 212. It says that where it is impossible to specify the particular date on which the offense was committed, it will be sufficient to state 2 dates between which the offense was committed. So we have authority which says it is not mandatory to mention a particular date. We have another supportive case, Chitranjan Das versus State of West Bengal AIR 1963 Supreme Court 1696. It was held that it is permissible to state in a charge under section 212 subsection 1 that the particular offense was committed on or about certain date. This makes things better and clear. Now let's cover subsection 2 of 212. It says when the accused is charged with criminal breach of trust or dishonest misappropriation of money or other movable property, it shall be sufficient to specify the gross sum, or as the case may be, described the movable property in respect of which the offense is alleged to have been committed and the dates between which the offense is alleged to have been committed without specifying particular items or exact dates, and the charge so framed shall be deemed to be a charge of one offense within the meaning of section 219. Section 219 we will cover later, but let me explain. It says 3 offenses of a same kind can be charged together if it is committed within a year. This is what is also mentioned in the condition of section 212 subsection 2, provided that the time included between the first and the last of such dates shall not exceed 1 year. So this is what the cutoff date has been mentioned. To mention the charge together, it must be within 1 year. Let's cover a case in this support as well. Wazir Singh versus Emperor AIR 1942 OUDH 89. It was held that subsection 2 of 212 was primarily enacted so that persons who showed a deficiency in the accounts with which they were entrusted could be convicted of criminal misappropriation even when it could not be shown that they had misappropriated any specified sum. So if you're not sure how much amount has been misappropriated, even then you can charge him for misappropriation of money. Now we come to section 213. It speaks about the manner in which the offense is committed. Let's cover it in detail. Section 213. It speaks about when manner of committing offense must be stated. Section 213 says, when the nature of a case is such that the particulars mentioned in section 211 and 212 does not give the accused sufficient notice of the matter with which he is charged. I hope you understand till here. For some reasons, if we think that it is not sufficiently giving the accused regarding the matter, regarding the offense he has been charged, so what we're gonna do? This is where section 213 informs us that the charge shall contain such particulars of the manner in which the offense was committed, as well as will be sufficient for that purpose. So I hope it is clear. When section 211 and 212 does not serve the purpose, explain the manner in which the offense was committed. Now let's cover the illustrations. A is accused of the theft of a certain article at a certain time and place. The charge need not set out the manner in which the theft was effected. Now it is clearly mentioned that we know the time and the place. So in this case, we don't need to explain the manner in which the theft was effected. Next illustration, B. It says A is accused of cheating B at a given time and place. The charge must set out the manner in which A cheated B. Now let's understand properly. Over here, the time and place, we know it. And we already covered that when we know the time and place, we don't need to explain the manner. But the offenses of cheating. Now how the person has cheated another, you need to explain that. I hope you got my point. Next. A is accused of giving false evidence at a given time and place. The charge must set out that portion of the evidence given by A which is alleged to be false. See, this is where we have to apply our mind. We cannot just say that false evidence is given at this date and time. How will accused know which false evidence? So we have to state that. This is what it's explaining, so that the accused can prepare his defense accordingly. Next. A is accused of obstructing B, a public servant, in the discharge of his public functions at a given time and place. Now the charge must set out the manner in which A obstructed B in the discharge of his functions. So I hope you're getting it a very clear vision that the charge must state clearly regarding the offense. Now writing a date and time of the offense for obstructing a public servant will not be sufficient over here. Because we have to understand that the accused must know that what action, how it was called obstruction, how it is an offense. Got it? Okay, let's cover the next one. A is accused of a murder of B at a given time and place. The charge need not state the manner in which A murdered B. Now, students may create a controversy over here. We need to understand how he was murdered. The murder itself states the offense. So the accused is given the notice that he's been charged under murder, which is sufficient for him to defend himself whether he is innocent or not. Next, A is accused of disobeying a direction of the law which intend to save B from punishment. Obeying traffic rule is an example for this. So the charge must set out the disobedience charged and the law infringed. Say for example, if we say that a person on this date and time has infringed the law by breaking the traffic rules, but this is not going to make him defend. What rule did I break? So you have to mention and state the disobedience charged and the law infringed, that he was overspeeding, he crossed the red light. Okay, now before we come back and study another section, Remember my words, little respect to elders, little love to kids will make this world a better place to live.